Your Lordship, last week when the roll came out, we learned that the matter has been moved from Her Ladyship Leqhashasha. It is now featuring before Her Ladyship Ntsane. And this morning I attended to her chambers around 9 or 9:10 thereabout, to request for an indulgence. I couldn't find your judge's clerk for assistance to get an indulgence. Unfortunately, when we got there, we found that this matter will only start in the afternoon. Yes, because that is what we were going to propose, but there were issues with the crowd. So your ladyship then suggested that we deal with her matter first, and then I would come back to you. And this is what I believe my learned friend was trying to convey, that we have just been asked to deal with the matter, but we have finalized the matter, my lady. By your lordship, I had appeared before her ladyship, so I keep saying
no problem.
yes, ma'am. So otherwise we can kick off, because that matter before Randara has been sorted. Thank you.
Thank you, my lord. My lord, may I confirm that His Lordship and the Lady Assessor got our submissions Friday. I arranged that they be ferried to the chambers because Nemateka could not be reached over mobile cell phone. And my lord, may I also confirm that this morning I did provide the index of authorities for some of the decisions I've quoted in the heads of argument. My lord and lady assessor, I don't know how much His Lordship allocates for me because to address. I think I had sought to identify the issues for which I'm going to persuade His Lordship to enter judgment. I just needed to be guided because I've prepared 13 pages of arguments, my lord, and I know you have read them. I don't know which angle would His Lordship wish me to start with, so that I get to the crisp issues. Thank you, my lord.
We may start off with the evidence of PW1 and
There's a copy,
in relation to count 1.
As a copy.
That will be count 1 relates to the murder of Honeycomb.
As a court, Mrs. Mokoko.
Yes.
Thank you, Mr.
And we will also be aware that the same witness touches on the entire evidence.
Yes,
touches on the matter.
Thank you, my lord.
Just to address the court on that witness evidence coupled with the evidence of PW9 and the evidence of PW3.
As a court,
I think they have something in common.
As a court,
Yeah.
My lord, with your permission, may I start to indicate that PW1 indicated in his evidence that the services of his 4+1 cab were solicited by accused number 1, and at the time his services were solicited, they were at Habia. My lord and lady assessor.
Let's make it this way so that we take it ahead.
Yes.
It's not disputed that PW1 went to Hatamai in the company of A1 and A2 and A4.
Yes, ma'am.
And then that Adamaja.
Yes, ma'am.
Yes. The question might be what actually transpired. You recall that the defense said, that's what I want you to address. I think that's the issue. Let's talk about A4. The defense said, even the previous examination was saying that A4 at all material times remained in the car.
Thank you, my lord.
Yes.
Thank you, my lord.
He did not get out of the car. There was evidence that A1 and A2 left the car, and then later on they joined him in the car with PW1, and then they met.
As a court, please.
You may zoom into that.
Thank you, my lord. My lord, perhaps let me take it 2 steps backward. When they were leaving the Abia location, PW1 had not been told that they were actually going to Radicanelo's place. He discovered that midway. But what is important, my lord, for purposes of common purpose, is that when he agreed to ferry them to Hatamai, it was A1, A2, and A4, my lord, who had previously met and discussed whatever they had discussed. I'm bringing this to the mold, my lord, to indicate that PW1 took them without knowing their intentions to the place. Whilst they were at the place, my lord, and I wish to take the Honorable Court to page 6 of our heads of arguments.
Yeah.
We've quoted the cross-examination that had been conducted,
Yeah.
which, my lord, indicate that the defense concede the fact that while they were at Hatamai, only A1 and A2 alighted the vehicle. That one has been confirmed in this cross-examination. And A4, my lord and lady assessor, remained in the car, holding the driver hostage. That's critical, my lord, because we now know that when they left Abia, they had a plan to execute. And now when A4 is left in the car, 2 allies to do the murder, we now gather the confirmation here that they had allocated duties accordingly. One would keep watch of the driver.
So what you are saying is that he's been there, he had a role to play to keep watch on the
Yes.
on PW1.
He had a role to play, my lord. He had a role to play, my lord. And my lord, one other critical element is that A1 and A2 have their guns, but A4 didn't have a gun. But as I've indicated, the critical role he played is central to the whole execution of the murder, because he kept watch and held the driver hostage.
Okay.
Yes, and my lord,
Yes.
I may now zoom, because I need to narrow down. I've written a lot, as His Lordship might have observed. I then zoom into page 9 of our heads of arguments, my lord. I've also dealt with the critical issue there around the scene of crime. The point, my lord, I wish to make here, and lady assessor, is that A1, A2, and A4 were present at the scene of crime. And it was executed according to their earlier execution plan. And my lord and lady assessor, there is a question here which I need to address myself to. about possession of guns. Here now we know that A1 and A2 had their guns. But as part of the larger scheme of conspiracy to murder Radiko Nelojoki, A4 must be taken as well to have been in possession of the gun because he was part of the plan. And my lords and lady assessor, the possession of a gun, according to the decided case I've quoted here, is either immediate or by extension to people who go together. I'm trying to locate that decision, but His Lordship and Lady Assessor would recall it. We have mentioned that he must as well, when they get convicted on the murder and on the illegal possession of firearms, A4 must too be convicted. My lords and lady assessor, PW1 did talk to Matsuso, Papiso Matsuso, my lord, at page 33 of our heads of argument.
Let me take you to this issue that I would like you to address.
Yes, my lord.
There was evidence that when A1 and A2 got out of the vehicle, they went straight into Ts'ehla FM yard.
Correct, ma'am.
And the defense said that A1 and A2 went to a secluded place to relieve themselves.
Correct, my lord.
And the reply of PW1 to that question was that he saw them entering the yard. And then the question that followed was that if they had entered the yard, the security guard posted there would have prevented them from or would have stopped them. Was there a basis that there was ever a security guard at the gate? And what will be your submission on the weight to be attached on the evidence of Peter regarding the point they exited the vehicle and his evidence that he saw them entering the Ts'ehla FM premises?
Thank you, my lord. Page 27 of our heads of argument. Page 27, my lords, whatever we have quoted there as answers His Lordship's question, that actually these people alighted, they went straight to Ts'ehla FM. It doesn't appear in evidence that they got resistance from the security guard. In fact, nothing of that sort was led in evidence. But what the court had been told, my lord, with the greatest respect, is that when they alighted, they went straight to their target. They shot at him several bullets. He was already in his car trying to get out to his home. They shot at him mercilessly to an extent that his car lost control and they kept on shooting at him. My lord, the person who had been told how this murder was executed, he was trembling whilst he was here. He was saying, Kumi told me he has never saw that level of Gestapo atrocity, cruelty perfected. When somebody was being shot, even when his car has lost control. And my lord and lady assessor, we have evidence before court that some cartridge cases were collected the following day at the Tamai shopping center. Very critical that I relate to this one, because that cartridge case that was found by the lady who works at Tamai Shopping Center was taken to ballistic examination alongside the guns, my lord. And, my lord, the ballistic expert testified that the results were positive. That cartridge case that had been found there had actually been fired from one of the guns that A1 and A2 used to kill Radikonelo. My lord and lady assessor.
Sorry, I'll keep on interjecting.
Yes, my lord.
I have issues that I would like to address the question.
Correct, my lord.
Now, let's get to this issue where the defense, and you recall that we held an inspection where we went to the scene.
Correct, my lord.
And we were pointed to a place where the defense, A1 and A2 said they stopped.
Correct, my lord.
To relieve themselves. And it was agreed that where they said they stopped, it was about a kilometer away from where Thomello FM is located.
Correct, my lord.
Now, take that with the defense's earlier questioning during those examinations that they had actually stopped at Ts'ehla FM premises, and these two gentlemen went out to relieve themselves.
Thank you, my lord.
Yes.
My lord, I'm trying to look for the page.
No, just
Okay, thank you, because I've already dealt with it in the heads. My lord, here is the situation. The reality of the matter is that when Inspector Siago was cross-examined, he was cross-examined in relation to the reconstruction of the crime of scene, which is at, my lord, opposite Tamai Shopping Center, which is also the place we call Thomello FM premises. That was the crime of scene to start with. That was constructed and reconstructed. It was not where we have been taken now for local inspection. That should be point number one, my lord. My lord, point number two, when he was cross-examined, both Kumi and Inspector Seko, they were very clear that the place where Radikonelo met his untimely death was Tamai Shopping Center or Thomello FM. You'll see, my lord, in the exchanges that had been quoted in our heads of arguments. There's no question about that. And, my lord, in the end, I'm going to ask that for the accused person to have wasted our time, to have taken us to a place different from the one they've gone to shoot Radikonelo, should be taken into consideration when I now deal with how much sentence must be given. So, my lord, with the greatest respect, the questions and answers solicited in cross-examination have established that the crime scene that was constructed and reconstructed is Tamai Shopping Center or opposite Thomello FM. So, in a single sentence, my lord, our answer is we were taken to a wrong place where no crime was committed, where no construction or reconstruction of the crime scene took place, and that was misleading to the Honorable Court.
Then there's this other issue that while the A1 and A2 had signaled for PW1 to stop and they entered the car.
Yes, ma'am.
You said PW2, if I'm correct, was on the phone.
Yes, ma'am.
Calling somebody to report that they had shot him and killed him.
And they've killed him.
Yes.
Yes, ma'am.
At that time, PW4 was still in the vehicle with them.
PW4,
I
my
mean
lord.
A4.
A4.
I meant to say A4.
He was still there.
Was still there. What
Yes.
would be your take on that?
Thank you, my lord. When the report was now made that we've killed him. PA4 was still there, and he acquiesced to the whole arrangement of a report being made. And my Lord, it's very important, I've highlighted this in our heads of arguments, that at no stage during the execution of murders has A4 dissociated himself from the entire scheme of conspiracy to murder. Not at all. That means, my Lord, in the submissions we're making is that he may not have fired a shot, he may not have pulled the trigger, but his participation, sharing of information, sharing reports, acquiescing to the whole conspiracy to murder, he must be held accountable. That is the essence of common purpose in our criminal law.
Okay.
Thank you, my Lord.
Let me ask you this. You recall that immediately after the murder of Radical Njoki, I think the following day, there was that emergency declared where there were restrictions on movement.
Correct, my Lord.
Of people.
Correct, my
You
Lord.
are aware?
Correct, my Lord.
Yes. That was as a result of that killing.
It was as a result of
It was following. It was a killing after another which had happened
correct, my Lord.
earlier. That was a matter of national now concern.
My Lord,
Everybody was affected by that emergency declaration where movement was restricted. What would be your take on that, taking that A4 was there but did not, says he did not participate? What would be your take on that? Did he do anything about that?
yes, my Lord. Thank you, my Lord. My Lord, I wish to advert to this question about the enormity of this crime. There was that restriction of movement because according to the police, not only was the emergency declared, but the police formed a special task team to deal with that, because now it has become a national issue to say a careless murder has happened, a radio personality killed. Meantime, the government was, my Lord, as I had indicated earlier, meantime, the government had embarked on strategies to deal with those murders which were happening week in, week out. And, my Lord, if A4 wished to dissociate himself from that conspiracy to murder Radical Njoki, he ought, in terms of the Criminal Procedure and Evidence Act, to have reported himself to say, I'm reporting a case of murder to which I was a party. I saw A1 and A2 killing Radical Njoki. He didn't do that. Allow me to tell you what they did instead, my Lord. They followed what was happening over social media, tried to gather their own private intelligence, which they later on used to leave to the Republic of South Africa when the net was closing in on them. That element, my Lord, is very critical for your consideration when you deal with the judgment. Because here we say we had a national disaster now. A person being killed at the gate of the premises where he works. My Lord, I need not to profile Radical Njoki. He's dead now. But Radical Njoki had many people who loved him, had many people who needed answers.
Let's not go there.
As a
I think you
conclusion.
have addressed my issue.
Thank you, my Lord.
Yeah.
Thank you, my Lord.
Now, I think I'll pose questions to you.
No, please, my Lord, I'm enjoying it because, like I've said, I've summarized everything in my head of arguments, so I expect to be interrogated on what I've said.
Now, let's go still on PW1's evidence.
Yes, my Lord.
What he testified to on the as to what had happened on the 20th of May
Thank you, my lord.
2023,
Yes, my lord.
where he said that he took A2 to Mazino, and then from there they went to Mukema in the evening.
Correct, my lord.
Then let's go straight to that incident where he said that they were directed where to go. Then later on, A1 and A2 went in, and then he said they were after certain incident.
Correct, my lord.
A1 and A2 joined in the car, and they were holding guns and a cell phone. And he said that they claimed that the gun belonged to the person they had shot along with his concubine.
Correct, my lord.
Yeah.
Correct, my lord. Let me start some steps.
What would be your submission on that?
Yes, my submission is, my lord, here again, we have another set of conspiracy to murder by the same accused person. It is now the following week, my lord. You remember the Radiko Nelejoki was shot on the 14th. The following week is the weekend is the 20th. And we have now the same people meeting again. And now moving to Mukema. My lord, evidence of PW1 is very clear that A1 and A2 directed him where to stop and where to park his car while they went to Wele Mothibe. He has not been contradicted on that. My lord, here is the proof of common purpose they shared to murder Mothibe. And the plan, my lord, was executed. This one was also careless murder, because PW2 and PW9 are the ones who have witnessed it, because now they saw A1 and A2 shooting at their target, and also in the process killing Thomello Ntsane, who had never featured in their plan of conspiracy to murder. And my lords, here again, we see the murder being executed in a reckless manner, heartless.
Okay, let's leave that for now.
As a court, please.
Yeah. What will be your submission on the evidence of PW2 and PW9 in relation to what happened while they were in the trees or in the aloes?
Thank you, my lord.
Do they corroborate each other on material respects?
My lord,
address the court of those.
Thank you, my lord. My lords, their evidence corroborates each other in significant material respects, because they are saying we hid ourselves in the aloes, and we saw them killing them. We saw them getting into the car after killing them to seize their gun, their cell phones, and some other items like money. There is no contradiction in their evidence, my lord, because here now they are very clear to say this is what A1 and A2 did, and we witnessed it.
Yeah.
Yes, my lord. Yes, my lord. Thank you.
Does PW1 also corroborate the evidence of PW9 and 2 in relation to what A1 and A2 came in possession were when they got to the vehicle.
Yes, my lord.
Yes.
They corroborate. Remember, my lord, and PW9 is Rapelan Chaka, my lord.
Yeah.
Yes. This one also operates a 4+1. His evidence is very significant in material respects because you will remember, my lord, that on the day A3 left to escape
No. Address me on this one that I've just brought to your attention. Does PW1 in his evidence corroborate what PW2 and PW9 said happened?
Correct.
So far as the items that were robbed of Mothibe and Mothibe are concerned.
Yes, my lord.
I want you to address
yes,
that.
they corroborate.
Yes.
They corroborate, my lord, and you will notice, or the court must have realized that their evidence is similar. Where now they say after the murder of Mothibe and Thomello Ntsane, Soto left behind in the village, and he handed in his gun to my lord.
No, it was PW1.
Yes.
Yes.
Yes,
He
ma'am.
said that when they came into the vehicle, they were in possession of the phone. Then he
Correct.
said to them, this phone is the one that's going to make you
To
arrested.
get arrested.
And then they discarded that.
They discarded that
Yes,
phone.
I just wanted you to.
Yes, my lord.
Yeah.
When they discarded that phone, they were trying to cut the network of possible investigations that will link them to the murder. And my lord, the court should take it into consideration that had to be discussed as well, as part of the common purpose, to say now, here is the phone. For so long as we have this phone with us, it is going to link us to the crime scene and things of that nature. Let's discard it. It was discarded as the court places.
And then PW1 said he asked them why they killed Mothibe, and he said that A2 answered that Mothibe made life difficult for his boy.
Correct.
You call that?
Correct, no. I recall that. Yes, I recall that. And they had a motive. That one goes to the issue of motive for killing him, my lord. And my lord, you must have realized my heads of arguments. I have summarized the themes which reflect on the motive they had for killing all those people they have killed.
Now, let's go to, because we are still on PW2 also.
Correct, my lord.
He said on one occasion, he was asked by Ewa
Yes, my lord. About the contact numbers.
about the Mothibe's contacts,
Correct, my lord.
and then he said he asked him what he needed them for,
Yes.
and he sounded, or he looked desperate for those
Yes.
contacts. That was his evidence.
And he became very brutal to say, I want to kill him.
Yes.
Yes, he was he said it in clear terms, I want to kill him. Yes,
Okay.
that's the court places.
Now, at a later stage, there was evidence that PW2 asked, inquired from A1 why they wanted, or he wanted Mothibe killed.
Yes,
And the reply was that Mothibe was problematic.
yes, problematic or troublesome. Yes. And my Lord, that is very important. Allow me to address myself to it. Because the context within which Mothibe was perceived to be troublesome here later became clear when now PW Mpoma, when now they roped in Mpoma Tamane, and here now I zoom in directly to A3. A3 calls Mpoma Tamane. They are at his shop, and he says, Mpa, look, I wish you to join our conspiracy to murder Mothibe, because we are sort of relieving you because Mothibe is a womanizer in the community and he's in love with your wife, which is something we don't approve here as your community people. Just zoom in to the plan to kill him. And my Lord, this one now explains why A1 said, no, we want to eliminate him, he's troublesome. Yes, yes, that should be the context as the court places.
Now, still on the evidence of PW2, he said that at one occasion he was in the company of himself, PW2,
Correct, my Lord.
and Ntsane.
And the
And then they met on the mountain top.
yes, my Lord. Yes, my Lord.
There was that conversation about when he said A3 asked him whether A1 and A2 had given them anything.
Yes.
About
3,000,
5,000 that
yes,
he had given to them, to A1 and A2, whether that had been shared with them.
Yes,
what
my
would be your submission?
Yes, my Lord. Thank you. My Lord, my submission to this one is this. A3 had thought that everyone who had been engaged in the conspiracy to murder had been handsomely rewarded. Because for him, he had channeled that money for it to be distributed. Hence, he had to follow on the matter to say, did every one of you get his deserved share? And PW2 then said, no, they didn't share with us anything. Hence, he made alternative arrangements for them to be handsomely rewarded as well, as the court places.
Then, in the same question, now, PW2 testified that A3 told him that he had ordered a hit on Mothibe.
Yes, ma'am.
And that his gun should be taken.
Yes, my Lord. And my Lord, this one is very important. This one is very important because PW2 is an accomplice witness. We had been sternly warned to disclose everything. And I've submitted in our heads of arguments that he had actually came here with the intention to testify to the utmost truth of what he knows. Here he says, A3 was very specific. I want the gun of Mothibe. Mothibe, it's a beautiful gun, I love it. So I have ordered a hit on him so that I get that gun. My Lord, fast forward, A3 got the gun, and A3, after being arrested, released the gun, exactly the gun of Mothibe, as the court places. As the court places. My Lord, you know I would enjoy answering your questions there because they also help me because mostly they have been articulated. The answers are in our heads of arguments, but for clarity purposes, I enjoy answering more because I didn't want to start wasting the course time. My lord, one other issue.
Let me ask you this. PW2 testified that after Mothibe had been shot and robbed of his gun, A1 shot at him.
Yes.
At Mothibe
with his gun. Yes, yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. My lord, the ballistic report. The ballistic report is not explicit on the cartridge cases which could have been found relating to the gun of Mothibe. I need to be frank with the court on that one. Yes, but what is important again is, my lord, with the greatest respect, PW3 was not contradicted in that evidence. PW2 was not contradicted in that evidence.
Now let's get to the evidence of PW. This one relates to the killing of Radical.
Yes, ma'am.
The conversation that took place between PW2, A1, A2, and A4.
Yes, ma'am.
Where PW2 said they came to his home in a blue Honda Fit, and they asked for contact from somebody residing in St. Michael's.
Yes, ma'am.
And then when the conversation went on, then it emerged that there was something to do with Radical.
Yes. Yes,
Can you
ma'am.
address the question?
My lord, they were so desperate to get the contact numbers of Radikone. And when that failed, they looked for ways now to get contacts of people in the neighborhood of St. Michael, because they actually needed Radikone. And my lord, PW2 is very clear in his evidence to say Radiconello was being looked after primarily because he was running initiation traditional school in competition with this other, with A3. And A3 was very clear when they were on top of the mountain to say, look, man, Radiconello must also die. Or I had previously ordered a hit on Radiconello, and PW2 asked, but why would Radiconello be killed? He said to him, look, you have not been initiated, Olekai, and you may not understand some of the issues of us people who are doing initiation schools, because they are shrouded in secrecy in the way we do our things. But for him, it was very clear Radiconello had to be terminated. Yes, my lord.
Oh.
Yes, my lord.
Let's get to the evidence of. I just want you to reconcile this evidence with
Yes,
the
ma'am.
events of his PW12, one Papiso Matosu.
Correct, my lord.
Remember, he said that he was somewhere when A2 called him to inquire about the the identity of the presenter on Ts'ehla FM.
Correct.
That
That evening.
that evening.
Correct, my lord.
Yeah.
Yes.
Then he replied that unfortunately he wasn't listening to the radio where he was because he was at the bar.
Correct, my lord.
Then and A2 then later on invited him to his place. When he found A2 in the company of other people listening to the radio.
Correct, my lord.
And then he was asked to
Identify
confirm
the voice.
the voice of the presenter. He said
Correct.
he recalled that he said it was Leqhashasha.
Correct, my lord.
Yeah.
Yes.
Yeah.
And my lord, let me take you further. That was the conversation for that day. Now, when Radikonelo had been killed, PW12 remembers, but they had asked me to identify the voice. What could have happened? It's very critical, my lord, because A2
Yeah.
is a personal friend to PW12.
Yeah.
Yes, they now discuss. Man, what could have happened? You sought to identify the voice of Radikonelo when he was on the radio. Now, Facebook and social media is awash with information that he was killed the previous day. Then, talking as friends, A2 tell him, no, we terminated him. Yes. And it's very critical, my lord, because here are friends talking, having background circumstances on which to base their discussion. And this one confines in the friend to say, well, yeah, it's us,
Yeah.
as the court places.
Now, I think this issue is surrounding the matter of Mothibe and as well. I want to take you to another witness. You take their evidence together. That of PW16, Detective Inspector Mokoko, and then what this evidence is all about. That you recall that PW1 said the vehicle had collided with
A war. Yes, my lord.
When he attended the scene, he said he found a 4x4 vehicle
Yes.
that had collided with the wall.
With the wall of the wall of Tama shopping center. Yes, my lord. Yes. The vehicle that had collided with the wall is the very same vehicle that PW1 talked about to say Leqhashasha was driving in it when he was moving out of the gate of Ts'ehla. So Inspector Mokoko now attended to the crime of scene, and the vehicle was still there. And you will notice, my lord, that we have the statement of the lady that works. It's here in my head of arguments, I may not recall.
Yes, but I remember.
Yes. So that lady says the following day, when he got to the workplace, there were classes all over because of that accident, and she found a cartridge case, and then she took it and handed over to Inspector Mokoko, because you will recall, my lord, Mokoko came to do the reconstruction of the crime of scene. So then that would mean the cartridge case was found there, and that cartridge case, my lord, I wish to remind the Honourable Court, went to ballistic examination and it confirmed that it was fired from one of those guns the accused were holding.
Okay.
As the court places.
Let me take you to the evidence of Sub-Inspector Butu
Yes, ma'am.
and Masenka.
Yes, ma'am.
Yes. About
The trip to
the trip to
Northwest.
Leicester. Yes.
Correct, my lord.
Yes.
My lord.
No, let me take you right there. It's not disputed that A3
Yes, ma'am.
called somebody.
Yes.
And it's also clear that there was a time that A3 called PW3.
Matamani. Correct, ma'am.
Yes.
Yes.
And where even A3 in his evidence confirmed that he gave Matamani some instructions to contact Butsunyana and
Correct.
stuff like that.
Yes, ma'am.
And they agree on that.
They agreed.
Yes. And now it's not even disputed that later on Matamani came along in the company of Butsunyana.
Yes.
And what transpired there, it's a matter of rather common cause.
Yeah, it's a rather matter of common cause, my lord. The place is Kuma,
Yeah.
opposite the graveyard,
Yeah.
in the province of Northwest, where now, following the instructions which had been issued by A3 to say, good people, look, I'm with the police from Lesotho. I'm still assisting them in their investigations. But significantly, I need those 3 guns because my intention is to hand them over to the police. My lord, a lady assessor, that instruction having been issued, all efforts were made by the people to whom the instruction had been communicated to avail the guns. And it's very important what A3 himself said. When now the guns were being brought, because those people who were bringing the guns have been alerted that A3 was with the police, they said, well, we don't want to get closer to you. You come, pick your things. And my lord, he himself is saying, Butsunyana shouted to say, hey, Munna, don't get to how. I simply translated to say, Butsunyana was very clear that I don't need to get closer to the car the police are driving in. We park in here, come and pick your items so that we leave. And my lord, and lady assessor, the critical aspect of what happened is that those guys, the 2, Matamani is driving and is in the company of Butsunyana. They just opened the boot of their car. They didn't even alight. They just opened the boot of their car to say, pick your items. And the A3, my lord and lady assessor, A3 took the items and went to the police, that is Sekubut and Madam Masenkan, with the black bag containing the guns. Thank you, my lord.
Now here is the version of the defense. That was the version that was put by the ground.
Yes, ma'am.
And during cross-examination of either Kubutu or Masenkane, the defense put the following question to him or her to say, yes, PW3 says the guns that he had were in a black bag.
Yes.
That was the question that was put to either Masenkan or Kubutu.
Oh, no, I remember the question.
The significant thing is that the question was put to them to say the guns
were in the
black bag.
Correct, ma'am.
Now let's get to the evidence of A3. A3 said that the things that were in the black bag were money and
gold. Yes, ma'am.
How do you reconcile the 2?
Thank you, my lord. My lord, A3 was cross-examined in relation to the contents of his affidavit when he was applying for bail. And he did concede that, yes, when I was applying for bail, I made it very clear that I cooperated in the investigations with the police and I've handed them the guns. But he says Look here, Mr. Leputing, I was being represented by the lawyer who didn't care about my interest. I had to substitute him at the later stage to get somebody senior to protect me, because for his part, he caused me to sign an affidavit that I had guns and I have handed them guns. I have handed the guns to the police. And my lord and the lady assessor, in the index of authorities I've provided, I've attached the judgment on the bail application. His Lordship will see at page 54. That's what had been summarized in the judgment to say, for instance, I wish to quote 5.1 of the judgment. Here the court held that in his sworn statement, the petitioner states the following as his exceptional circumstances: that he was arrested whilst he was on his way to surrender himself, that he had been in cooperation with the police, that he surrendered the guns to the police, that he is innocent. So, my lords, the court should reject any suggestion that the black bag contained gold and money. The black bag contained the 3 guns, which A3 undertook to avail to the police. And those 3 guns, my lord, after he had cooperated in handing them over to the police, they were taken to the ballistic examinations. And the ballistic reports had been filed off record. And my lord, I need to comment about something here. The ballistic expert, our very own Mr. Tato Mukote, was very helpful to this honorable court in explaining the steps undertaken in the ballistic examination and the outcome. And that, my lord, I wish to submit with the greatest respect that the court should accept that report of an expert as binding on the A3, because the guns were examined after he had handed them over. The cartridge cases collected from Mokema and those collected at Thomello FM went to ballistic examination as well, and the results confirmed they had been fired from those guns. The A3 surrendered. So, my lord, with the greatest respect, I'm submitting that our attitude is the court should reject any afterthought that A3 did not hand over the guns.
Let's get to this other issue. There was evidence by PW2 that A3 had said to him that he wanted Mothibe hit and his gun taken.
Correct, ma'am.
Then there was that evidence that when A1 and A2 parted ways after the shooting incident at Mokema.
Yes, ma'am.
There's evidence that A1 handed his gun to PW2. He handed 2 guns to A2.
Yes, he handed 2 guns to A2.
The one belonging to himself
and the one from Mothibe. Yes.
Dropped from Mothibe.
Yes, the one from Mothibe.
Then A2 left with those guns.
Correct, ma'am. Correct, ma'am.
Now, let's get to the evidence of this witness who said he took
Makapal.
He
took A2 to the border gate.
The border gate where
yes, ma'am.
Yes, some business.
Yes, ma'am. My lord,
Yes,
it's, I think the witness is PW15.
Yes.
Makapal. My lord and lady assessor, the evidence of Makapala is very clear. I operate a taxi, a 4+1 cab. A2 solicits my services to transport him to the border gate. I charge him a return charge, presupposing that the trip was to take off from that side of Habia to the border gate. And he says, there had to be one lady to be picked. Yes, okay, thank you, my Lord.
Just address me on that aspect relating to
the gun.
The gun.
Thank you, my Lord.
Where they could have ended.
Thank you, my Lord. My Lord, I need to say the guns is now from Mukema. It is with A2 at Habia. A2 now takes it to Blackstop, to where A3 stays. But here is the significant area where I wish to remind the Honorable Court. A3, PW15 says, when they were in the taxi, everybody admired the gun. But what is important is, when they got to the border gate, they found someone there. And this someone had been assigned to pick the gun by A3, but he brings along a message from A3 to say,
No. There's no evidence to that.
My Lord, the record is a bit bulky. Allow me to remind you.
No,
There's
that witness,
yes,
PW50,
yes,
did not know whom
was
A2 was going to meet.
Yes, yes.
What is clear is that there was this gun taken by A2 to be delivered to somebody.
Yes.
At the border. As to the identity of that person,
he did not know.
He did not know.
And he considered that as much. And my Lord, but here is the important thing to which I would want us to tie the loose laces. The trip, as previously contemplated, was from Habia to the border gate. But now, with the instructions being delivered to A2 from that person that PW15 did not know was, take this money and deliver it to my mother at Mukema. So now, the coordinates of the trip are now changing, because the initial plan was we are from Habia to the border gate. But owing to the instructions now, which I submit, my Lord, they were from A3. The trip now changes from the border gate. A50 now drives to Mukema because...
No, maybe you don't understand what I wanted you to address the court.
Okay, no.
I just wanted you to address the court on whether there is any link
yes.
between the guns that were taken from the gun that was taken from Mothibe at Mukema.
Yes, Mama.
And then the two guns that were seen now being taken by A2 to Maseru.
Okay.
And then later on, the very same guns, the two guns that were used to shoot at Mothibe and Mothibe's personal gun are later on now found in possession of A3.
Thank you,
then
Mama.
Address the court on that in relation to the evidence of PW50 and the evidence of PW and A2 as well,
yes.
as to that trip to the border post.
Thank you, my Lord. Thank you, my Lord. My Lord, allow me to start it at the tail end. At the tail end, we find the three guns talked about in evidence and reflected in the ballistic report being retrieved from one person, A3. from his place in Klerksdorp, Northwest, in the Republic of South Africa. That is the tail end. The modalities now, according to evidence, are that the guns were delivered to Maseru. A2 actually took them. A1 left in the village. I'm saying A1 left in the village, my lord, because it's very significant to remind the court what happened. The following day, after Mothibe had been killed, A1 also attended the scene of crime, pretending he didn't know anything. But now, to be specific on the question of the court, those 3 guns are taken by A2 to Maseru, Abia, where he stays. From Abia, evidence connects them to the person at the border gate, who then ferried them forward to Northwest. And at Northwest, when A3 is arrested, and he is asked a simple question, are you related to these Famukian stars and things of that nature? He says, allow me to cooperate. Allow me to cooperate, the guns are with me.
Okay.
I will arrange. Yes. Thank you, Melo. Thank you, Melo.
Now the last thing that I would like to address the court on is that there was that expression of desire, according to the evidence of PW2, that you would like to have the gun of Mothibe.
Yes.
How do you link that with the guns now later on?
Yes, thank you, my lord. My lord, an expression of interest by A3 to eventually own the gun of Mothibe. According to the evidence, it came to pass because eventually Mothibe is dead and his gun is in the possession of A3. That means PW2 was a trustworthy witness to this one of court because whatever he testified to had been corroborated in different stages, and eventually the gun that A3 wished to possess after Mothibe would have been robbed of that gun is retrieved from him by his own way and by his own assisting the police to go to his house and to get it. Yes, my lord. Yes.
If the court were to believe that the evidence of PW2,
yes, my lord,
is credible,
yes, my lord,
insofar as it relates to A3,
yes, my lord,
particularly about his desire to have Mothibe's gun, and that he had ordered a hit on Mothibe.
yes, my lord.
But it's a matter of common cause.
I know it is.
If, according to the evidence of PW2 and PW9, that A3 is never mentioned, that he was either at Tamai Shopping Center on the 14th, nor was he at
Yes.
Mokema
Yes,
on the
on the
20th,
20th,
when
correct.
Mothibe and Thomello Ntsane were met.
yes, yes, my lord.
Would there be any evidence that would now connect A3 with
Yes,
this
thank you,
two?
my lord. Thank you, my lord. Yes. My lord, there is evidence.
Let me simply put it to you. Address the court answering that question on the issue of common.
Common purpose, yes. I was coming to address the issue of common purpose. My lord, on the elements of common purpose, the evidence has established that every detail in the instructions of A3 to have people killed were executed. He wanted Leqhashasha dead. That plan was executed in his absence, but instructions are his. He wanted Mothibe dead because he wanted the Mothibe's gun. That conspiracy to murder him was executed, but in his absence. But, my lord, it all centers on him as the kingpin, as the court places.
Anything else?
My lord, the court probably had an occasion to look into our heads of arguments. My lord, we ask, and we earnestly ask, that these 4 accused be convicted on all counts. We have established that through evidence as the court places. Thank you.
I think we all need a short break, yeah?
That's a good question. There must be a meeting of the parties where the particular crime is planned, and then there must be participants in that crime, and they must participate fully well with the knowledge that they are furthering a crime that had already been planned. And the individuals must accordingly participate, even after the fact. They can still be found to have participated and convicted. But our submission, Your Lordship, in this particular instance is that the Crown has not met that. There's absolutely no evidence that the planning of radical Joki was ever done by any of the accused persons, where they met and made a conclusion to commit this murder. And primarily, Your Lordship, on this count, we submit that accused number 3 and 4 must be acquitted.
While you are there, there might not have been evidence to say on a particular day A1, A2, and A4 met to have radical Nolojoki murder.
Yeah.
Now, let's look at the evidence of PW1.
Yeah.
Where you see A1, A2, and A4 together.
Yes.
When you look at their actions, one might say it demonstrates that at a particular time, these people had made a plan and had agreed on how that plan should be executed.
Yes.
Wouldn't that suffice to say their actions demonstrate that they must have planned, they must have met, and they have come up with a plan on how to execute their plan?
My Lord, my submission in that respect is that this court should not be drawn to a situation where it is asked to assume.
No.
Yeah.
Get me right, Mr. Mala. I'm saying there's evidence by PW1 that
I was,
on the 14th, there's no assumption. There's evidence that A1,
they were together.
A2, and A4 were together in a taxi that took them to Hatton.
Yes, ma'am.
And then there's evidence as to what transpired there.
Yes, ma'am.
Yes.
And my Lord, I'm still saying, and I submit that would not constitute, being in the presence of people, does not constitute a plan or a conspiracy to commit murder. But primarily, my Lord, what is important here is that the court should look at what the evidence is about, the evidence that was presented. And in relation to A4, because, my Lord, there's clear evidence that accused number 3 was not there. But let us talk about A4. A4, my Lord, uncontroverted evidence is there that he simply joined these people because they are related to each other, they are friends, and he wanted to enjoy beer with them. There's absolutely no suggestion, even from PW1, to say that, well, it was discussed prior to them leaving Habia, the bar where they met, there was a discussion about going to Hatamai to commit a certain deed. In fact, my lord, PW1 also says, myself, because there was no discussion, I only came to find out at a later stage when we were already in the car. So clearly, my lord, I think that absolves PW4. In his own evidence, he says that I joined these people simply because they are friends. It is not controverted even under cross-examination. It is accepted. And my lord, this then brings us also to the question of his participation. My learned friend submits for the crown that he was holding people hostage. My lord, where does that evidence come from? There is no evidence that Peter A4 was holding anyone hostage. In fact, he was even unarmed on that particular day. What was he holding them hostage with? So, for all intents and purposes, my lord, we submit at this particular stage, A4 knew nothing about what was going to happen. Like the others, my lord, he had on the road when he was talking to other people that, well, there's this issue of A2 talking to someone telephonically, that now let us go to Masiano again. But for all intents and purposes, the purpose of that trip, he was unaware of from inception.
I want to believe that at a later stage, immediately after the shooting incident, then A4 became aware of what had happened. Because PW1 also was there. He was told, he said A1 and A2 told him why they were getting out of the car with their pistols. And then he was told that they were going to shoot at the Radiconelo Jogi. And then he made inquired from them as to why they didn't tell him in advance. All this happened in the presence of A4. That's correct, my lord.
And this is where, my lord, that if we were to accept the evidence of PW4, of PW1, the issue, my lord, now comes in relation to A4, that having learned of this situation, did he play a role in furtherance of the crime or not? And the evidence is very clear, my lord.
But the question at the same time will be, did he disassociate himself?
This is where, my lord, I'm saying he did. He did disassociate himself. And by doing so, my lord, it is when he alighted the vehicle and left. If he was party and parcel.
Remember, he left at Hamatala when the man had completely been done.
Yes, my lord. But
wouldn't it have been different if he had left at a scene when the incident occurred? When they came back to say, no, we have shot and killed him, then he left at that scene.
My lord, it would be unfair to do so. It would be unfair because this thing was happening in a series. You should remember, my lord, that by this time that these people were in the car and the car was leaving. So it would be unfair just for someone to say, well, take me out here. And you should remember, my lord, that if he showed that disassociation explicitly there, that is putting his own life into danger. So to be fair, my lord, at that particular stage, one would anticipate that one would say, oh, I didn't know that these people are going to do this, but let me keep quiet. At the first moment that I get, what do? I alight the vehicle and leave. So I think it is only fair, my lord, to demonstrate that that is a disassociation of A4 from further participating in the matter. It would be unfair to expect that right there at that moment, that is where he would tell them that, or he would show. In fact, he wouldn't even tell, because then people would start saying, well, this one is going to be a pimp. And it is not like, my lord, they went from bar hopping to bar hopping and he was with them the rest of the time. No. To the contrary, PW1 is the one who associated himself with them. Because he didn't alight the vehicle, he even went further and went to the bar, even after learning of this. But what did PW884 do? He immediately alighted. And my lord, if credit is given to PW1, why shouldn't 84 also receive the same credit from the court? This is my submission, my lord, with due respect, that indeed he disassociated himself. Therefore, the doctrine of common purpose has not been fulfilled in relation to A4. Now, yes,
let's while we are still
yes, ma'am.
talking about the evidence of PW1 in relation to count 1, because the focus is now on A4. What would be your take on the testimony of PW2 that on a particular day A1, A2, and A4 came to his house and were making those inquiries about Radical Joki,
Yes,
and that the plan was to have him killed?
yes,
You remember that?
well, yes, brother.
And that the feud was about the initiation school.
Yes.
Now, take that piece of evidence of PW2 vis-a-vis the evidence of PW1, that on that fateful day, A4 was present in the
Yes, my lord, again, even on that one, I think the position has been clarified. But let me stick solely on the version of PW2. My lord, it is our submission even in that respect that at no stage did PW2 show any engagement towards this inquiry. All that PW2 could say was that I could see that A4 was present in the vehicle. Now, my lord, I still maintain, being present or in the presence of someone who later commits a crime, that cannot be a situation where the court can conclude that one was associating himself. And especially, my lord, in the circumstances where all these people know each other, from growing up, from going to the initiation school, or just being village boys, who, when one arrives, they would be happy, please let us consume alcohol together. They are friends. Now, the relevance of PW2, my lord, as I submit, he was only brought in just to bring A4 to be in the picture. But his participation, he never inquired. He never even approached the house. If the evidence is correct, my interpretation, he never even approached the area where these people were doing the times. This is my submission, my lord, with respect. I was
sorry to interject. I was asking that question because my record says that a PW2 testified that A1, A4 alighted from the plane.
I appreciate that, my lord. But if my record serves me well, my lord, it was A1 and A2 that approached. That is what the statement says and the record. It is A1 and A2 that came and then they started talking. And the person who was actually doing the talking was A2. Whilst A1, my lord, was outside the car and he saw them. This is my submission, my lord. So my issue is that there was never any direct engagement between PW2 and A4 at any stage. For him to say, well, I am also interested to find out the numbers of people and what and what and what. So my submission, my lord, is very frank that what the Crown is trying to do here is to extend this doctrine of common purpose and apply it in circumstances where it is not applicable, at least in relation to A4. This is my submission, my lord, that for all intents and purposes, in relation to the participation regarding Radical Joki, my lord, A4 is not implicated in any manner. And the insinuations that were made cannot in any way, beyond reasonable doubt, be a conclusion that A4 was commensurate or participated in the commission of that offense. And to this extent, my lord,
What would be your reaction if you were to be asked that this failure to report that incident thereafter indicates that he was part of the plan, of the mission? What will be your reaction to that?
my lord, at this particular instance, it is my submission that like all the other people, there was no reporting of this incident until when the police approached all the respective witnesses and they interviewed them. Now, my lord, you should recall that the situation here, my lord, was one such where the A4 says, I was not aware or I was not even part of any planning. He did not know of what was happening. And let us assume, my lord, that at that particular stage, he came to learn during the commission of the offense that something was happening. He then disassociated himself. The question still arises. Would he be in a position now to put his own life in danger? And this is where, my lord, our submission is that for all intents and purposes, he then decided that I don't want to be party and parcel to this. But of course, my lord, his take on it, even in evidence, is that when he then saw that he was being looked for, that is when he was prepared to come to the police and say, look, as far as I'm aware, this is what happened.
So what we are saying is that the court should excuse his failure to report.
Yes.
On the basis that he was scared for his life.
That would be correct.
Did he give evidence to that effect?
Well, my lord, his evidence was to the effect that, as far as I'm concerned, I was not and I did not participate in the crime. And he showed evidence as to why he did not participate in the crime. And
you see, Mr. Molapo, his version would have maybe been different if the version at all times had been, we have never been at that place. But now the way you are making your submissions is that the defense says, admits that A1, A2, and A4 were at the crime scene. But what singles out A4 from that is that he did not participate as at all material times. He remained in the vehicle.
yes, my lord, I am arguing it from a perspective where you are accepting the evidence of PW1 or the other witness. That is the perspective. And if the perspective of PW1 is to be believed, then, my lord, it is our submission that, and this is part of our evidence, because being in that area is not in dispute. That is not in dispute at all. It is accepted by all the witnesses who says that, yes, we were with PW1, we did go to the area of Hatama, but we were not participant in the shooting. And this is what also A1 and A2 says, which we are saying, my lord, that the court still has to find whether there is credible and tangible evidence that directly A1 and A2 shot the Likhang Joe. And that is the second leg, because, my lord, what I wanted to do was to remove, issues what I can call the easier ones first. But at the end of the day, my lord, it is still the defense of accused number 1 and number 2 to say, no, but we never shot Likhang Joe. And it is and it takes it further, my lord. My learned friend was asked here, said, what about this issue of the security guard? That issue is very important, my lord, and cannot be ignored, because there is evidence that was placed that there is a security guard that guards that area, you see, and who even testified that he also heard the shots, but he did not observe.
Who's that?
I think it was an admitted statement, my lord. It's one of the admitted statements. There is a security guard to that effect. So there was a security there, my lord, and it is common cause. And this is extremely important on the basis that it is alleged that they jumped the fence, then they went out the gate. And it was put, but the security would have observed this, raised an alarm at least, even if he did not stop them, but he would have raised an alarm, he would have been aware. And this becomes important, my lord, regarding the very same issue. And this should also be distinguished, my lord, very importantly, with the area as to where the accused persons say they were when they were at Hatama. And this becomes material, my lord, because the Crown never took us for an inspection in loco. The Crown never did that. So even now, my lord, the assumptions and the distinctions that the court is drawing that the shooting happened, Radikonelo was shot at a particular area and this is where, the court doesn't have a picture of that. It is only the accused person.
The picture that the court had is that Thomello FM is about a kilometer away from the intersection where the defense is set.
That is the only picture the court had. Yeah. And that is the version. And my lord, there's no other version because the crowd failed to take us for an inspection in local. So our submission, my lord, is how then is the evidence of A1 and A2 controverted regarding where they stopped the vehicle, where they urinated?
Okay, now let's go to
and my lord, just before we pass that, there's this issue of the telephonic conversation between A2 and another person. Yeah. That evidence is also not controverted that A2, in reference to that, was actually talking to someone who had left, who was now at Masianoke. That is why they left and headed directly there. And it only makes sense.
Then what will be your submission on the content of the communication between A2 and that unidentified person, to the extent that A2 was here saying, no, we have shot him and killed him?
My lord, this is where our submission here now even goes to the question of these particular witnesses. And it is our submission, my lord, that the totality of all the evidence that has been brought here makes no direct bearing on the death of either of the deceased persons. But what you will see, my lord, is that because the police failed to investigate this matter, my lord, in a proper fashion and getting evidence, that is where, my lord, we even referred earlier on that they used what you call the reactive method, where now they would use torture and what in order for witnesses to give evidence. This would include even the accomplice witnesses themselves. And deliberately, my lord, what you would see is that each and every witness has been designed for the crowd to simply say something about the accused and put them at the scene at one stage or the other. But there is no direct evidence that no one can say, I actually saw this shooting. None of them. And we are still, my lord, because I'll come to Mama when we talk of Mokoko. But in relation to this particular instance, that is the attempt that was made by the crowd. This is why, my lord, they even attempted, which was declared inadmissible, to try and bring evidence of village people there who apparently certain confessions were made when they were before the police. So that proposition, my lord, our submission is that this is something that this court should also not ignore, the method on which this matter was investigated to try and implicate any of the accused persons. This is why, my lord, at the end of the day, A3, it is suggested that it is a kingpin. For reasons that we do not know, because each and every person here simply talks of him, and they talk of him after the event. None of them say that, well, before the event, this is what they meant, A3 made any planning. Every one of them talks about A3 after the event. when he comes home and is discussing. Let us even accept that when he came on the 18th, he asked about the death of Radikwe Job. It was public information. But based on that, then they put in a small insinuation. Well, I wanted him dead because of initiation school issue. My lord, our submission is that that can't be a motive. Simply because we are initiated with someone, I would want them dead.
Now let's move to Mokoko.
Yes.
Yes. Focusing on the evidence of PW2 and PW9.
Yes.
They corroborate each other on material respects.
Thank you. My lord, let us come to those two witnesses. The first issue, my lord, is that accused number 9, my lord, was not declared, my lord? PW9 was not declared as an accomplice witness. Yeah. And this was by design, my lord. This was by design. The design is this, my lord. Once you are declared an accomplice witness, it means that you come before court and you are a confessed murderer. And of course, my lord, this court still has the power that once you are declared an accomplice, at the end of the case, this court can decide the fate of that person. Whether he gave evidence that would impugn him from being charged. Now, what happened, my lord, in this case, when I say this by design? PW2 comes in, is declared an accomplice. After cross-examination, the Crown realizes that, well, we need to have a corroboration. But in order for PW9 to participate in this matter and he is absolved, let us not declare him as an accomplice. Now, the question, my lord, in those circumstances is where a person, and he said that himself, he said that, yes, I should have been an accomplice in this matter under cross-examination. That can this court take his evidence as corroborating in circumstances where the right procedures were not followed? Because now the court cannot even call him to say, I want you to be charged, in circumstances where he was not declared an accomplice witness. So, for all intents and purposes, my lord, it is our submission that this court should not regard the two witnesses as corroborating each other. In terms of what is required by the law when it comes to accomplice witnessing. But pertinently, my lord, those two witnesses, or especially PW2, denies any guilt or participation in the murder of these two people. So you will see that by design, my lord, he is only coming in and brought by the Crown.
You recall that he was quite cautious about that question because, according to him, the way he was expressing himself, he understood to mean that to participate meant actually pulling a trigger like A1 and A2. That's what the court got from him as his impression about, because he kept saying,
Yes, my lord, but then we even took it back. We even took it back under cross-examination and we went through the phases. And this is where ultimately, at the end of the day, we even put it to him that, actually, you are the one who pulled the trigger.
Yeah.
And our defense, my lord, the defense was simply that What this thing is all about is that A2 wanted to buy a firearm. And you are the one who actually proposed that, no, there's a firearm that is available. You can come and get it. And then they together with PW9 are the ones that orchestrated the murder, stole the firearm, and then gave it to accused number 2 and accused number 1.
Yeah.
Now, our submission, my Lord, for all intents and purposes, at the very best, my Lord, what the Crown has only managed to prove is that accused number 1 and number 2 are guilty of having received the stolen property. But they have not been charged with that. But at best, my Lord, our submission is that this is what, because it is conceded, my Lord, at the end of the day, that with the evidence that came in, they found out that the gun that had been sold by PW2 to A1 and to A2 actually belonged to Mothibe. But our submission, my Lord, is for all intents and purposes, the evidence was always very clear that A2 wanted a firearm. There's never any suggestion that it is said that I want a firearm that belongs to Mothibe. And to get that firearm, go and kill him. Our submission is that there's no evidence to that effect. And my Lord, it is our submission that the defense witnesses were not incredible at all. That is why even the Crown now cannot say that. Say, well, they came to court and they gave evidence, but the evidence was incredible. Our submission, my Lord, is that that evidence is probable. And once it is probable, my Lord, the court is enjoined, for all intents and purposes, to find in favor of the accused person and acquit them. Now, also, my Lord, in relation to A3, we submit, my Lord, that the evidence of PW2 was merely meant by design to put A3 in a situation where he seems to have confessed to PW2. But PW2 has come and given evidence. Says, no, but this is not even my friend. He's an acquaintance of my cousin. But importantly, again, my Lord, all this apparent confession and what was done after the event.
What will be your submission on the evidence that of Mr. Mokoko, the ballistic expert, who confirmed that both the guns that had been retrieved from the accused persons were actually linked with the 2 murders, with the 3 murders?
Well, my Lord, my take on that is that evidence of the ballistic does not say that the guns were retrieved from the accused person. That is my submission. Because, my Lord, what...
I just wonder, do you doubt the findings?
No, my Lord. We have no issue with the findings at all. What we have an issue is that, contrary to what Marlon and Friend says, the ballistic now links those firearms to the accused person.
Yeah.
For all intents and purposes, my Lord, no firearms were retrieved from the accused person. And my Lord, on both the police officers, Sekubutu, Mere Masenka, A3 was very direct that that black bag contained money and precious metals. That has always been his line of defense. And my lord, I'm just addressing this because your lordship said that when it was put, it was suggested that there were firearms. My lord, that was not, I've read the record. It was a situation, my lord, where we were playing the devil's advocate in cross-examination. And the way it was put, my lord, was that, look, if you took guns in South Africa, those guns were in a black bag. And then the witness said, correct. Then we said,
on air that particular time and confirmed that it was Leqhashasha. Remember that?
yes, ma'am.
Yes.
Well, my lord, my issue with that evidence here is that evidence, my lord, has no direct nexus to the killing of the accused, to the killing of Radikolo Njoki. Because it is not like, my lord, it is suggested that immediately after he said this is when these people went to find Leqhashasha and they shot him. My lord,
Wouldn't you now connect the dots to say, this person has been asking about Mr. Molapo's whereabouts, and I confirmed to him, yes, Mr. Molapo's in Ribe, currently is he the one, yes. Then later on, mishaps happened to Mr. Molapo. Wouldn't you think that this person must have been connected to that?
Well, my lord, there are many suppositions. That's why I'm having difficulty, because we are assuming, and this is a murder trial, my lord, where at least you must provide either direct evidence or even that circumstantial evidence must be one that links to the murder, to the occurrence of the murder. So here's a situation where people made discussion. It's like the discussion that was had when Matamani was saying, this man, you know, he's taking my wife.
No, I was saying it in the context of the evidence presented. Let's take the evidence of PW1.
Yeah.
Let's take the evidence of PW2, and then the evidence of this witness,
Yes.
so that the same person, A2, who had been making these inquiries about Joki,
Yes.
the same evening.
Yeah.
A2 is seen by somebody in that vicinity. Then that person whom A2 had been making inquiries about ends up dead.
That is why, my lord, I'm saying it is far-fetched in the context. You should remember, my lord, the context of Matamani at that particular time, and I'm likening this to that situation. It happened months before when they were at the shop of A3, and there was a discussion that this man has taken my wife, you know, and he does so, you know, he does so without any remorse. And the Crown wants to say that that discussion that was had during drinks by people who were upset means that A3 therefore could have said, well, go and kill that person or assist me to it. But I'm saying, my lord, that it is so far-fetched that the incident of the inquiry must be commensurate with the death itself. So when people are discussing, my lord, they are interested for whatever reason. What if the reason was that we want to know this Radikolo, he's a good disc jockey, he's a good DJ, you know. So to simply, my lord, for the Crown to rely on an issue that at one stage we discussed the whereabouts of Mr. Mla, that in essence now constitutes the fact that it means that he had a plan or he had an intention to kill him. Our submission, my lord, is that that is far-fetched, and we should take it to that extent. Okay. Yes, no.
Let's look at the evidence of PW3 Mpo Mataman.
Yes, my lord.
He said on one occasion he was in a company of he found, let me put it the way he said. He said that he found A3 who was in the company of A1 and A2. And they inquired about whether he had seen Mothibe.
Yes, my lord.
And he said he had not seen him for quite some time.
Yeah.
And then A2 then asked him whether he had Mothibe's contact, which he confirmed. And then they asked him to call him. Then he called him and he arranged, he told Mothibe that he wanted them to go out of the villages because he was bored, so that they could enjoy themselves. And Mothibe said he would call him later. Then later he called to apologize that he was quite busy. Then subsequent to that, PW3 called A2 to tell him that Mothibe was seen at Mahlawati location. And A2 told him that that was no use because he had no ammunition on him at that particular time. Therefore, he could not shoot him. You remember that?
Yes, my lord.
Yes. Can you?
Well, my lord, as I'm saying again, even this evidence by itself, the way it was presented, to my submission, my lord, it doesn't mean A3 or A1 or A2 made any plan to go and execute Mothibe. And the only reason, my lord, is that it is very clear that from the conversation, it was Batamane who wanted to meet Mothibe, who then responded that he's busy. So when A3 then sees him, he says, well, you send Mothibe, he's busy, but I see him at Mahlabati. What is wrong with that?
No, I'm asking you in the context that it had been communicated to him that the plan was to kill him. You remember that had been put to PW3 to say the plan was to kill him. That's why A2 replied to him that that plan cannot work because to kill him cannot work today because I don't have ammunition.
Yes, no.
You see, is that connection?
And at that particular, and this was months before, my lord, which was saying it was not even commensurate with the incident. But the point, my lord, is that insofar as the issue of this, my lord, even under cross-examination, it was actually put, and he accepted that, yes, A3 never suggested to me that I should go and kill A1. But it was a discussion which was said, when I'm in a hotel, it's something about it. So that is where it ends. That's where it starts and that's where it ends. But the issue, my lord, here is that does that now link A3 to the planning of what happened on the 20th? And at that particular juncture, my lord, why then was this this witness not used? Because at the particular time, the gripe at the time, which was discussed among friends, was this man taking this man's wife. So those reasons and motive at that particular time, my lord, falls away.
Okay.
So our submission, my lord, is that really I think we are the Crown is grappling at straws and twigs to try and implicate A3 and or A4 in this whole issue. My lord, with the greatest respect, it is our submission, my lord, we have filed our heads that A1 and A2, I mean A3 and A4, my lord, there is absolutely no evidence that links them to the commission of this offense. And with respect to the other accused persons, my lord, A1 and A2, our submission, my Lord, is that the evidence that is presented does not pass the bar for a crime of murder to have been proven beyond reasonable doubt. And as we submit, my Lord, at best, the court can only convict these accused persons of count 5, A1 and A2. That is the theft of the firearms. Because, my Lord, from the evidence and what was submitted before court, despite the fact that A1 and A2 are
Count 5?
count 5, my Lord, is Section 3.2 of the Internal Security Act, my Lord.
Related to firearms.
Yes, okay. In fact, it's count 4, my Lord, because count 5 is unlawful possession. Count 4 is the one that talks of the theft. And that one, my Lord, we must accept and concede to this court that this is what A2 said. He was aware that PW2 was going to get a firearm, though he does not know where it came from. But he was told by PW2 that I have a firearm, and an illegal firearm for that matter, my Lord, to sell to you. And PW2 even says, yes, that's what I deal with. I acquire and sell illegal firearms. So at best, my Lord, this is what we are saying, because he then accepts that, well, I received this firearm, which I then subsequently sold at the border. And it is our submission, my Lord, that evidence, there is no evidence that he gave this firearm, contrary to what my learned friend says, that he gave the firearm to A3. He gave it to an unknown person.
No, I'm lost, Mr. Boy.
Yes, ma'am.
You were saying A1 and A2
Yeah.
could at least be found guilty of count 4.
Yes, ma'am. And
That relates to use of violence to
Yes.
accuse in order to steal.
yes, ma'am. And I'm saying this, my
That
Lord.
means they were received.
No, my Lord. This is where we differ. You see, now, my Lord, we are applying the concept of common purpose. So we are not even saying, and we are not suggesting that they directly took the firearm from him. But the question, my Lord, all comes that after PW2 and PW9 stole the firearm using violence, they then gave it to A1 and A2. And it is a concession, my Lord, that obviously when that firearm was received, because there was no exchange of any formal licenses, then it means that this accused person knew that this firearm must be stolen. So I'm simply extending it, my Lord, and saying, for all intents and purposes, if the court was to stretch the principle of common purposes, it would only apply to that extent of the theft. That you knew that a gun was going to be stolen, it was stolen, you received it, and you participated in it, in that you then went to sell it off and dispose of it. So that is where, my Lord, I was just simply saying to the court that if we were to extend that, at least this is where the court would say, well, this is the situation. But in relation to their death, my Lord, our submission is that it was never their idea with PW2 or any other witness that to retrieve this gun, someone must be killed. This is where our point of departure comes. Thank you, my lord.
Anything else?
My lord, that is my submission, our submission. And we rely on our heads of argument. We submit, my lord, that A3 and A4 are entitled to acquittal on all counts. A1 and A2, my lord, we also submit that are entitled to an acquittal on all the murder charges, together with the one of unlawful possession of a fire. They were never found in unlawful possession of fire. That would be all.
My lord, we stand and fall by our submitted heads of arguments. Safe to say, my colleague is trying to stand a pyramid on its apex. I'll tell you why he's trying to stand a pyramid on its apex. He's accepting the ballistic report. The ballistic report that connects the commission of crimes to the firearms which have been used, the firearms which have been recovered from his client. He's now saying they should be convicted of using violence. The violence, we have said, which has been used to kill Mothibe and to murder him in order to rob him his guns. We're leaving it to the court, my lord, to say we stand and fall by our heads of argument, but in the end, Crown has proved this case beyond reasonable doubt. Thank you, my lord and lady assessor.
I must say that this has been a very long trial with so many witnesses, and the court will have to deliver judgment in this matter in the very near future. The court will not be sleeping because this is quite lengthy trial. And the court will deliver judgment in this matter on the 3rd of December. It will be on a Wednesday.
Thank you, ma'am.
We are Christian.
Another question.
My lord, I will approach your judge's leg, my lord, for him to make a small note for me. I have a matter, it's a DCEO matter, but just so that I'm given a few hours off, but I will approach her to liaise with her that week.
You could ask Mr. Malabila to stand in for you for judgment.
Well, my understanding, my lord, is that after judgment there will be other issues. It's not just automatic.
Yes.
But I will make arrangements.
Yes, it's quite lengthy,
Yeah.
and I depending on the outcome, will deliver judgment on that. Whatever happens, we deal with it on that.
That's the court.
The court has finally had submissions in this lengthy trial.
Re go tla qeta ho mamela dingangisano tsena tse bileng telele ka tsa nyeoe ena.
And the court will deliver judgment in this matter on the 3rd of December this year.
Mme le go tla ntsha judgment ya lona ka di 3 ka December selemong sona sena.
You understand? The matter is therefore postponed to the 3rd of December this year.
As a court,
And you are excused, Mr. Mokoko.
as a court proceedings.